Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. This is Josh Sharfstein. Today, we return to guns and the courts. I speak with Kelly Roskam, the Director of Law and Policy for the Johns Hopkins Center for Gun Violence Solutions. We discuss a recent decision of the United States Court of Appeals for the Fifth Circuit to allow a man subject to a domestic violence restraining order to keep his guns. Let's listen. Kelly Roskam, thank you so much for joining me in Public Health on Call. Before we get into the legal side of the story, I want to start with the public health side of this issue. What are we talking about here?
Well, what we're talking about here are people who commit domestic violence against their intimate partners and their families having access to firearms. Over half of women murdered in the United States are murdered by an intimate partner. And nearly half of those are done using firearms.
And so, because of this serious risk of lethal violence for people involved in intimate partner violence, a number of states have policies related to guns. Is that right?
Yes, absolutely. Approximately 39 states and the District of Columbia have laws prohibiting people who are subject to domestic violence protection orders from purchasing or possessing firearms. Additionally, federal law prohibits persons who are subject to domestic violence protective orders from purchasing or possessing firearms.
Seems like a pretty obvious, important step to take.
Absolutely. An incredibly important step to take. And some states have taken that one step further to ensure that those individuals who are prohibited from having firearms are actually giving them up.
What kind of evidence exists to support this policy?
There is a robust body of evidence to show that where these prohibitions exist, particularly where we mandate that these individuals relinquish firearms, there are substantial reductions in intimate partner homicide.
So, to just wrap this up, we have a very serious problem of people using guns to shoot intimate partners. Recognizing this problem, states have put in place policies to allow for the removal of guns while there is an active restraining order. Those policies have been studied and shown to be associated with reduced murders.
Yes, exactly. And I do want to emphasize that firearms are used by domestic abusers not just to injure and kill intimate partners, but they're also used to threaten and coerce their intimate partners. And in addition to the harm that is experienced by people experiencing abuse, a study by my colleague, Lisa Geller, showed that 68% of mass shooters had a history of domestic violence or killed their intimate partner.
So you're making a very strong case for this policy. Why are we having this podcast then?
It all goes back to a Supreme Court decision from June of last year called New York State Rifle and Pistol Association versus Bruen, where the court said courts evaluating Second Amendment cases should no longer consider whether the law is substantially related or closely related to effectuating public safety. What they need to look to is whether or not the modern law is relevantly similar to historical laws, perhaps at the founding, but also maybe around the time of Reconstruction. It's not exactly clear.
So at issue is whether these policies to take away guns of people who are posing a direct threat to intimate partners, whether those policies can survive this Supreme Court decision. That's what we're talking about.
Exactly.
And incredibly, the decision said, in order to answer this question for any gun policy, you really can't look at whether the policy actually works and whether it saves lives. It's just this historical question that you're mentioning.
Yes. We're looking for an historical pedigree, some undetermined period of United States history.
So tell me about this first case that has been bubbling up related to this.
So the Fifth Circuit, which covers Texas, Louisiana, and Mississippi, recently issued an opinion in a case called United States versus Rahimi, where they found that the federal law prohibiting persons subject to domestic violence protective orders violates the Second Amendment under this new test.
So what was the story behind the case?
In this current case, an individual named Rahimi agreed to a protective order after allegedly assaulting his girlfriend. He was then involved in no fewer than 5 shooting incidents in Texas.
And yet he wanted to keep his guns.
Yes, and the Fifth Circuit says he can.
What was the legal basis for the Fifth Circuit giving guns back to someone with a record of such intimate partner violence?
So the Fifth Circuit is pretty clear that they're not looking at whether or not this is a good, safe, and responsible person to have firearms. What they found is that the federal law is not relevantly similar to several different types of historical laws.
So going back to the Supreme Court case, they look right past whether or not the law worked, whether or not he posed a direct threat to people. And sorry, the court said, is there a historical basis for taking someone's guns away in this kind of situation?
Yes. And I think they will readily admit that this is not the kind of person that we would want to have firearms.
Notwithstanding that, they gave them back because of this historical question. Is there a historical argument that it would be reasonable to take away somebody's guns who pose a direct threat to somebody else?
Absolutely. There are several different categories of historical laws that I would determine to be relevantly similar. Many courts have identified an historical tradition in the United States of disarming people who were perceived at the time to be dangerous. Now, these are based on classifications that we would find discriminatory and abhorrent today, but it shows a general principle that we can disarm dangerous people and that we should do so based on our understanding of dangerousness today.
Why didn't the court follow that? What did the court argue instead?
So it's interesting because the court issued 2 opinions in this case, an original one and a substitute. In the first opinion, the court said these historical laws disarmed people based on broad categories, proxies for dangerousness, whereas the federal law prohibited people based on an individualized assessment of dangerousness. Essentially, what they said is the federal law is too good at identifying dangerous people. And the historical laws were concerned with people who posed a risk to public safety, not a particular individual.
And then they had a do-over opinion.
Yes. Then they filed a substitute.
And what did that say?
So they got rid of the language around the broad categories. I'm assuming because they faced a lot of public criticism about that part of the opinion. But they did keep the analysis related to the fact that they consider these historical laws to be concerned with public safety rather than the safety of an individual, despite, as I mentioned, the fact that 68% of mass shooters, a big public concern, have a history of domestic violence.
So what we have here is the Supreme Court in a big decision last June saying that the constitutionality of gun laws cannot rest on whether they actually work. And then saying, go and argue about the history. And then you have a court now, a court of appeals, that has said, well, when we look at the history, we can't find a basis for taking away the guns of somebody who is quite possibly ready to use them on an intimate partner.
Exactly. And this is a really foreseeable consequence of a test articulated by the court with a real lack of clarity. Not just the Fifth Circuit, but other courts are grappling with what it means to be relevantly similar. How similar do they have to be? I think you and I can look at these historical laws and say, wow, this looks really similar. They're effectuating a very similar purpose, and they're doing it in a very similar way. And the Fifth Circuit says, no, this is not close enough.
So what happens now?
What happens now is that the government has indicated that they are going to appeal the decision. They have 90 days from the issuance of the decision to appeal to the Supreme Court. The Supreme Court can decide to take it or not. If they don't, the Fifth Circuit decision will stay in place.
And so the Supreme Court, one way or the other, will have a chance to say whether or not its views of the Second Amendment preclude keeping guns from the hands of people who are quite possibly going to use them against intimate partners.
Yes.
I can't imagine that this is a promising development for evidence-based gun policy to save lives in the United States.
That is something that we've been really grappling with at the center. And it is my very firm belief that there is still a role for evidence in these Second Amendment cases. And what it means is incorporating it in a different way. So if you must look to historical laws, many historical laws were passed for the same reason they were passed today, which is to protect public safety. To the extent that we historically disarmed dangerous people, evidence has so much to say about who is and is not dangerous today. And that's where I think we still have an enormous role to play as people involved in and researching public health matters.
Well, from your lips to the Supreme Court's ears, thank you very much, Kelly Roskam, for joining me today.
Thank you.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.